In this video, I'm going to take a look, and this will be of interest to you, I think, if you are a casual worker or on some sort of a self-employed independent contractor contract or some sort of temporary contract whereby you may be doing or may have a contract for 5, 6, 7 hours a week, but in fact you're doing much more than that. And this video will address some of the legislative changes which are coming in March of 2019. So next month, I'm making this video on the 17th of February 2019. So this deals with the whole question of banded hours contracts and so-called bogus self-employment and so on. There's big changes coming in from March 2019. This is courtesy of a bill, the Employment Miscellaneous Provisions Bill of 2017, which will become the Employment Miscellaneous Provisions Act of 2018. The changes are coming in. The law is due to commence in March of 2019. The purpose of the bill was to deal with so-called precarious work, 0 hours contracts and uncertain working conditions for employees in industries which would have typically relied to a great degree on the flexibility in the employment contract. Service industries, for example, retail, hospitality, hotels, tourism and so on. They are the type of industries where you may see these types of contracts fairly prevalent. There are 7 big changes. The first one is that the employee is entitled to have 5 core terms of employment within 5 days of starting the job set out. So the employer must give a written statement of 5 core terms of employment within 5 days of starting the job. This is a big change. Current situation is that the employer has up to 2 months to give the statement of employment. And in many cases, this doesn't actually happen at all. So I've come across many employees who simply don't have written contracts of employment. But it will become a criminal offence. Certainly some of the breaches of this act are criminal offences for employers, so the penalties are quite strong. But the 5 core terms then within 5 days include the full name and of employer-employee, the address of the employer, the expected duration of the employment contract, the method of or rate of pay or the method of calculating the pay, and the expected normal working day and week. Second big change has to do with banded hours contracts. The employee will have a statutory entitlement to a banded hours contract where their contractual working hours over the previous 12 months do not reflect their actual working hours. This may occur, for example, if an employee has a contract for, say, 5 hours a week, when in fact they're doing 15 or 20 or 25. They will have a statutory entitlement to a banded hours contract for the actual hours that they were working over the previous 12 months. So that will be the 15 or 20 or 25. So if the employee requests such a contract, he or she must be given the banded hours contract unless 1. The employee's claim is not supported by evidence, 2. There have been significant adverse changes in the employer's business in the previous 12 months, 3. The hours worked in the previous 12 months were brought about by a temporary situation which no longer exists. There are 8 bands in total set out in the Act, ranging from Band A, which is 3 to 6 hours per week, up to Band H, which is 36 hours and over per week. Once an employee is placed on a particular band, she's entitled to work, or he's entitled to work, an average of those hours for the following 12 months. Third big change is in relation to the designation of employees. An employer can be held criminally liable if she incorrectly designates an employee as self-employed. There's imprisonment of up to 12 months and fines of up to €5,000 as maximum penalties. The employer has a defence, however, if he can show that he exercised due diligence and took all reasonable precautions when arriving at the designation of employer or employee, or self-employed contractor rather, or employee. There is a prohibition then on 0 hours contracts. Currently 0 hours contracts are lawful, but there is a prohibition coming in on 0 hours contracts unless used in specific exceptional circumstances of genuine casual employment and where they are essential for the needs of the business in the short term or in emergency situations. The fifth big change is to do with continuity of employment. Employees who are given a series of fixed-term contracts will be deemed as being on layoff and will accumulate, therefore, continuous service for the purpose of protections from various employment law statutes. So simply giving an employee a series of short-term contracts won't break the designation of continuous service. Number 6, there's a new minimum payment. This will be an entitlement for employees who are not called into work on any given week. The employee will be entitled to 25% of their weekly contracted hours. Number 7, the Act makes provision for tough penalties for employers. The bill provides strong sanctions against employers for penalising employees who seek to enforce their rights under this bill, and also strong penalties for not implementing the provisions of this bill. My name is Terry Gorry. I'm a solicitor in Enfield, County Meath. I hope you find this video useful. If you do, you might give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, hit the subscribe button down below. I bring out new videos each week on a Wednesday morning and Saturday morning.